welcome back to Doing It He Said. We are going down a rabbit hole together today. So I found myself Googling up Judge Wentzell, which is Nick's judge in his drug case. Nick, for the record, is Nicholas Rekieta, a long-nosed lawyer who allegedly gave his 8-year-old methamphetamines. So I Googled up the judge today, just curious about the guy, I guess. And I was reading in one of his, he was a state's attorney before he became a judge. And in one of his cases, the state appealed a conviction because the mandatory minimums, the jury found someone guilty of a drug crime, and the judge stayed their sentence, but the state argued that the sentence couldn't be stayed because the judge doesn't have the authority to do that because there are mandatory minimums. And so I decided to look it up. All commitments to the Commissioner of Correction for imprisonment to the defendant are without minimum terms except when the sentence is to life imprisonment as required by law and except as otherwise provided in this chapter. If you did a crime with a dangerous weapon, if you used a firearm, if your drug offense, notwithstanding section 609.035, I clicked on that. We're going to look at that. Whenever a defendant is subject to a mandatory minimum sentence for a felony violation of Chapter 152, the minimum sentence imposed under this section shall be consecutive to that imposed under Chapter whatever. So we're going to look at these. Crime punishable under different provisions. If a person's conduct constitutes more than one offense under the laws of the state, the person may be punished for only one of the offenses and a conviction or acquittal. I hear drug offense. Okay, so we looked at that, notwithstanding that section. That section didn't seem like it applied to us anyways. We need to go look. Okay, so we're in the right area. We are in 152. And it said, other than a violation of section 152.021, subdivision 2B, which isn't his charge, Nick's charge is 22. The minimum sentence imposed under this section shall be consecutive to that imposed under Chapter 152. So does this one have a mandatory minimum? Not sure if I mentioned this, but we are in a rabbit hole together. Second degree. Penalty 1 or 2, and it is not subsequent controlled substance. The person shall be committed to the Commissioner of Corrections not less than 3 years. Damn, if the conviction is a subsequent controlled substance conviction. Holy fuck. Mandatory minimums means he needs to get the fuck out of Minnesota because he gonna violate this. So there is a mandatory minimum if this is your second offense. Mandatory 3 years. Okay, so that means he's no way at all gonna get even close to 3 years. That means he's not doing any time for this. A second conviction of the same exact thing would get him a minimum 3 years. Okay, so I don't think we're dealing with mandatory minimums. That's why I wanted to look, because I don't have a bet on it, but I do have like an intellectual bet. I don't think Nick is going to do jail for this. Because for several reasons. First time offense, nonviolent crime, showing the rehab. Well, I don't even know if he did rehab, but showing the clean drug testing, blah, 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 all the shits. I think he gets probation. And if he violates that in some way, then he will get put in jail. That doesn't mean I don't think he's going to get like 3 years, but I don't think he goes to jail. So that is how that rabbit hole actually got me. This I didn't read. It has a Stephen Wentzell, Assistant County Attorney, as the respondent, and appellant challenges his conviction for second-degree drug possession of a controlled substance, arguing that the district court erred by denying his motion to suppress methamphetamine found when the police searched his purse. Facts. Law enforcement agents of the Drug and Gang Enforcement Don't Give Two Fucks, DGTF, working with a confidential informant, CI, arranged a controlled buy of methamphetamine at Emilio Ozornia's home. Ozornia took the informant into his bedroom and locked the door. Although the informant was ultimately unable to purchase meth, the informant observed meth and meth paraphernalia in the bedroom. Based on this information, police obtained a search warrant for the home. Wow. On November 4th, 2015, before executing the warrant, police observed appellant Abel Ricardo Mendoza III in a car outside of Ozornia's home. Ozornia approached the car and spoke with Mendoza. As Mendoza exited the car and entered the house with Ozornia, he carried a silver and black purse. Soon after Ozornia and Mendoza entered the home, police executed the warrant. Both men were handcuffed and pat searched for weapons. While pat searching Mendoza, the agent felt that what he believed to be a large amount of cash. He also felt what he believed was a device for smoking marijuana. What? And a pill bottle that he believed contained a controlled substance. A device for smoking marijuana in his pocket? He retrieved the pill bottle. It contained synthetic marijuana. Oh no, that shit is bad for you. The men were then taken outside and placed in the back of squad cars. The GTF agent, Robert Brenes, oh, that's the same guy in the next case, recognized Mendoza, that is the same guy, from prior contact and knew that Mendoza had multiple drug convictions and was a suspected gang member. After Mendoza and Rosonia were secured in the squad cars, police searched the silver and black purse and the bedroom, and the agent found a baggie containing 8.478 grams of meth inside the purse. The agent also found a baggie full of what he believed to be a large amount of meth in plain view on the bedroom floor, only a few feet from where they were standing. After these items were found, they were arrested and taken to jail. Mendoza was charged with second-degree sales of a controlled substance and second-degree possession of a controlled substance. The charges related to the meth in the purse. Mendoza moved to suppress meth as the fruit of an illegal search. At an omnibus hearing, Agent Branes, who was the agent in charge of executing the warrant, testified that even if the purse had not been searched, Mendoza would have been arrested for possession of the meth found in plain view on the bedroom floor. He also testified that, as Mendoza's property, the purse would have been brought with Mendoza to jail. He testified that the jail has a policy of searching all inmates and their property. The search allows the property to be inventoried and stored until the inmate is released. The district court denied Mendoza's motion. The district court concluded that while the warrant for the other guy's house could not justify the search of Mendoza's purse, the search was lawful as a search incident to Mendoza's arrest for the methamphetamine found on the bedroom floor. The district court also determined that had the purse not been searched at the house, the meth in the purse would inevitably have been discovered during an inventory search of the purse at jail. Allegedly, cops. Mendoza agreed to stipulate to the state's case to obtain review of the pretrial ruling. The state dismissed the sale count, and the possession count was submitted to the district court based on the testimony and exhibits received at the omnibus hearing, as well as a report on the substances. The district court found Mendoza guilty of second-degree possession of a controlled substance for the meth found inside the purse. The first district court sentenced him to 75 months in prison, which was at the bottom of a presumptive sentencing range. This appeal followed. Decision. Mendoza suppression. Mendoza argues that the district court erred by denying his motion to suppress the drugs found in his purse. When reviewing a pretrial order on a motion to suppress evidence, the court reviews the district court's factual findings for clear error. That this court reviews de novo whether district court's factual findings support its decision. Mendoza claims that the district court erred in the application of both the search incident to arrest doctrine and the inevitability discovery doctrine. We first address the inevitable discovery doctrine. Generally, warrantless searches are per se unreasonable. In this case, a district court determined, and the state concedes, that the warrant to search the house did not entitle police to search the purse. They concluded that a purse is so closely associated that a person that it does not fall within the ambit of a warrant authorized to search a premise. Accordingly, unless one of the well-delineated exceptions to the warrant preliminary requirements applies, the search of Mendoza's purse was unconstitutional. The state bears the burden of establishing an exception to the warrant requirement. The United States Supreme Court adopted the inevitable discovery doctrine as an exception to the exclusionary rule to ensure that the exclusion of evidence that would inevitably have been discovered does not put the government in a worse position because the police would have obtained the evidence if no misconduct had taken place. Police officers may conduct an inventory search whenever an arrestee is to be jailed as part of a standardized procedure, and in doing so may examine all items to remove the arrestee person their personal possession. The district court determined that if the purse had not been searched at the scene, Mendoza would have been arrested for possession of the meth found in plain view on the bedroom floor. The purse would have been taken with him to jail and subjected to a lawful inventory search. Because the meth in the purse would inevitably have been found during this search, the district court concluded that the meth in the purse was admissible. We agree. I did not think they were going to agree, because how do they know he would have even taken it to jail and been searched? Like, maybe you're just... I guess you have to keep it with you. Ugh, that sucks. What if you're like, hey, homie, you're sorry your house got warranted and whatever, but can I put this in your safe? It's my thing. Could he? Because seriously, that sucks. How do they know he would have taken it to jail? That's pre-crime. The cops took it to jail, arrest that officer. When police executed the warrant, they found Mendoza and the guy in the bedroom with the door locked. Who gives a crap? They could have been doing SECKS. Neither the homeowner nor Mendoza opened the door when the police announced their presence. The meth on the floor was found in plain view, only a few feet from where they were standing. That seems really strange. Why'd they put the meth on the ground? Well, this house is methy. Multiple agents testified that it was very unusual for a large amount of meth to be out in plain view. Mendoza also had a large amount of cash on his person, and police knew that Mendoza had drug convictions and was a suspected gang member. Damn, they did some profiling. All these facts provide probable cause that Mendoza, either exclusively or jointly with the homeowner, constructively possessed the meth found on the floor. That's some bullshit. Stating that probable cause to arrest exists when the objective facts are such that under the circumstances, a person of ordinary care and prudence would entertain an honest and strong suspicion that a crime had been committed. Okay, fine. A person may constructively possess contraband jointly with another person. Oh, I see. So they can both possess something that's on the ground. That's another bullshit, but I'm so glad I don't live in Minnesota. Not just because the water turns all the dudes gay and the women into home-wrecking whores. Not just because of that. There's also a huge Muslim presence. And I love Jesus, and I'm gonna draw Muhammad. Okay, I'm getting off track. I was just joking about that. That's just a bad joke. In addition, Agent Burness testified that if the purse had not been searched, Mendoza would have been arrested for possession of the meth found on the floor. The next question is whether the state established that the purse could have and would have been taken with Mendoza to jail. Here we go. Most case law dealing with inventory searches involves vehicles. In that context, the Supreme Court has recognized a caretaking authority to impound a vehicle to protect the defendant's property from theft and police from claims arising therefrom. Hold on a second. Okay, sorry, I almost died of, I don't know, it was like a sneeze that got away from me, turned to a cough. And okay, most case law dealing with inventory searches involve vehicles where the court had recognized a caretaking authority to impound a vehicle. That's some bullshit. Like, we don't want your car to get robbed on the side of the road, so we're going to take it with us. And since we took it with us, we're going to search it. Now that we searched it, there's drugs in it. That's the bullshit. Courts give deference to police caretaking procedures designed to secure and protect vehicles and their contents within police custody. The key question is to reasonableness of the inventory search, which is determined by asking whether police carried out the search in accordance with standard procedures in the local police department. Moreover, even if less intrusive means exist for protecting property, the Fourth Amendment does not require such means. Police could have and would have taken the purse with Mendoza to jail pursuant to their caretaking authority. Agent Burness testified that the purse would have been taken with Mendoza to jail because, as a matter of course, property of individuals that are arrested are brought to the jail. Given the context of Mendoza's presence in the house, it also would have been reasonable for the agents to take the purse with Mendoza to jail in order to protect it and make it available to Mendoza upon his release. Police saw Mendoza carry the purse from the car into the home, and Mendoza had his hands on the purse when police entered the bedroom. The state established by preponderance of the evidence that the meth in the purse inevitably would have been discovered during a lawful inventory search. The district court did not err by denying Mendoza's motion to suppress on this ground. Because we conclude that the meth is admissible under the inevitable discovery doctrine, we need not address Mendoza's challenge to the district court's application of the search incident to arrest doctrine. Damn. I thought you had a case, Sir Mendoza. I'm sorry I took all your money for all them hours of my precious research. When Mendoza committed his offense on November 25th, possession of 8 grams of meth was a second-degree controlled substance crime, carrying a statutory sentence of 40 years. Possession of 8 grams of meth is 40 fucking years. Oh, for a person with Mendoza's criminal score. Oh, criminal history score. It's a game. He had a high score, but he didn't. He should have took up golf. He went for the low score. Oh man, this sucks. What is that like? Let's do the math. 75 divided by 12. 6 years. What is 100? 105 divided by 12. 6 to 8 years. Oh my god. Was it worth it? Like, I'm pretty sure meth's not that great. It doesn't taste as good as your freedom and your fucking teeth and your skin and probably your mom's trust. Okay, so if you're following this, the law changed. Back in the day, 8.4 grams was a second-degree possession of controlled substance crime. After they redid their laws and got their shit straight, that became 5th degree. 5th is actually way, way, way better than 2nd. Right now, Nick, let me just show you. 2nd degree drug possession crime. So while that is no longer, what I'm trying to say is secondary drug possession, now it's more, you get to have more drugs. You get to have at least 25 grams. This is what the sentence looked like for that. This is probably what Nick's sentence looks like. And they can stay his sentence because he's a first-time offender. That's his one chance. And he's probably read this. He's not, wow, I almost said he's not an idiot. His attorney maybe read this. Because Mendoza committed his offense on November 2015, he is not entitled to the application of the amendments. Blah, 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 yada, yada, yada. Affirmed. Alrighty then. And this was one that Judge Stephen Wentzell was on. Judge Stephen Wentzell is Nick's judge. I had planned to do super nice show, being very informative, and tell you guys what the causes of midlife crisis were, because that's what Nick is going through. It's a freaking textbook. And what happens is you like get older and you start examining all of the choices that you made, and you start going, did I want to be a dad? Did I want to be an attorney? Am I fucking blah, 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 blah? And I feel like we got to see it live with Nick. He examined all the stuff and was like, turns out I don't want any of these things. And I would rather try to get my dick involved in my life a little bit more or whatever. I want to save some hoes and fix bitches. And so, yeah, he's totally having a midlife. He has failed at it. I don't know what happens. Like, I haven't looked much past this. I'm not sure if everyone wakes up from their midlife and goes, oh no, what have I done? Or if it's just, I have no idea. I bet when he shakes hands with you, he has the most limp wrist there is. He's definitely the most limp wristed attorney in Minnesota. And then I was going to go over some stuff about aging and what Jung said about it, but I don't feel like it anymore. Now, this judge that is looking over Nick's case when he was an attorney, he didn't fuck around. He does not like drug people. And Nick's entering as a drug people. He's been actively trying to get drugs out of Minnesota for a long time. When I read about the judge's history, first of all, his brother, a different judge, did his like swearing in thing, which I thought was pretty cool. But what I noticed was that he was standing there with his wife and his child, and that was a little while ago. You know, I think they said it was 2017 that he became a judge. So the kid in the picture is no longer a kid. He's probably a teenager. Drugs are probably a big issue he wants to keep his kid out of. And so with people like Nick allegedly giving it to their 9-year-old, or even just fucking being all willy-nilly about his shitty lifestyle, exposing Aaron's kids to it, exposing his own children to it, breaking up his marriage for it. Like, drugs are bad, okay? And Nova said he's gonna get a year plus 1 day, or a year minus 1 day. Something weird about a day plus or minus a day. But so far, Nova has been right about almost nothing. So yeah, stay tuned for As the World Turns, the Midlife Crisis series happening in Minnesota with the non-practicing attorney and non-practicing father, non-practicing husband, non-practicing friend, non-practicing streamer, non-practicing Christian, very much practicing alcoholic. Okay. I've made this in outro too many times. I just need you to know that the attorney that I just read to you, the one that was arguing that it was a good search, that guy was going to go to jail anyways, that they both owned the drugs, and all of that. That is the judge now in Nick's case. So if he thinks he has a judge that's somehow going to give deference to the rights of individuals and sovereignty and the Constitution, he's wrong. That's just not going to happen here. I still think that he's not going to actually serve jail time. I don't even know if I said that correctly. I think he will be sentenced to jail, but have a state sentence, and then hopefully not violate and never end up seeing jail time. Heavy asterisks on hopefully not violate.